Welcome to Aspen Leading Edge. I'm Patty Roberts from St. Mary's University School of Law, and today's guests include Laurie Levenson. She is the professor of law and David W. Burcham Chair in Ethical Advocacy at Loyola Marymount University, and Erwin Chemerinsky, the 13th Dean of Berkeley Law School, also the Jesse H. Choper Distinguished Professor of Law. Thank you both for being guests today.
It's really great to be here.
Thank you so much for having us.
Well, I am excited to have both of you on here because you have a book about to come out, a fifth edition of a book on criminal procedure. And so that will be out later this fall. And I understand this is not your first rodeo writing together. And maybe we can talk a little bit about how you all have been co-authors through the last several decades.
In the mid-1990s, Laurie was the leading commentator in the country with regard to the O.J. Simpson case. I also did a good deal of commentary, and she and I came to realize that there was no code of ethics for legal commentators, and we each saw some behavior that to us was deeply concerning. And so we decided to write an article together on how to be and what are the ethics of being a legal commentator. And it got far more attention than I think either of us could have imagined. We did some follow-up articles to it. And I have to say that writing with Laurie was just truly a joy. In 2000, after the Rampart scandal in Los Angeles, and this involved police officers framing innocent people by planting evidence, then lying on court to gain convictions, we were asked to do a report on the Los Angeles Police Department and worked very closely as co-authors, including some others, on that. And I think that as a result of having worked together, when the opportunity came to write a criminal procedure casebook with Laurie, it was one that I really wanted to take advantage of.
And I would join and say it's always a privilege and pleasure to work with Erwin. I mean, just the way he thinks and presents the information just makes it easy and fruitful to do so. So when we had the opportunity to write a book, and we had similar approaches, frankly, as to what a casebook would do and be helpful for professors, we jumped at it.
So I very much remember that O.J. Simpson trial. My grandmother at the time used videotapes, VHS tapes, and taped the whole thing. So maybe you all were included in that commentary. But it's fascinating that you found that there was a need for legal ethics for commentators. And did it take off? Is it something that has continued today that commentators follow?
Well, I think it's actually been really helpful, not just for the professors, because now they can say, gee, I'd love to do that for the media, but I really shouldn't. But also for the media to get an education as to what the role of law professors could be. And there's no shortage of high-profile cases. We're done with OJ, but we're on to the 100 next more trials of the century that are likely coming our way.
Very fascinating. So now come to present day, and the fifth edition of Criminal Procedure is coming out. And if I would appreciate if you'd tell us a little bit about the book. I understand it's very student friendly in its the manner of writing. But what's new to this fifth edition that our criminal procedure faculty out there can learn about?
I do want to back up before I answer your direct question by emphasizing what I think makes this book unique. And our goal was to make it the most student-friendly book we could. My experience with other criminal procedure books, constitutional law books, is they were filled with rhetorical questions to the students in the notes. My students were always so frustrated with that, where they had notes that had excerpts from law review articles, but not with enough context that the students knew how to use them. And so the goal that Laurie and I had for this book was it would have major cases, it would have more minor cases that we excerpt, it would have essays to introduce the material. I never believe that anyone learns by confusion. And so the goal was clarity in the presentation. I'm teaching criminal procedure investigations this semester from the fourth edition, and I'm gratified by the students' reaction to the book with regard to its clarity and its organization, and it's being presented in a student-friendly way.
I think Erwin hit on the key here, which is organization. We're not into sort of moving all around the place and just have the students spend all their time trying to put it together. It is important that they read cases, and I think we've done a decent or good job at editing those cases so they can do so. But if there are additional materials that professors like to use to teach, we don't just jam them into the book. We have a supplemental folder with the book that professors can go to find problem sets or articles about cases or even tapes. We have 2 DVDs full of excerpts from famous cases or cases that have been in the news that professors can use to make their points.
Those sound like extraordinary resources for the professors. I'm sure that the students really appreciate this organization that you have. And one of the things when I was reading up on the new edition, I noticed was that you all make sure to explore policy before you're heading into doctrine specific. So can you share a little bit about that?
Sure. Let's take, for example, the exclusionary rule, the judicially created principle that evidence should be admitted as a result of police violation of the Constitution. The exclusionary rule is enormously controversial. So what we try to do is present for the students a summary of the arguments on both sides. One thing that Laurie and I haven't talked about is we really aim for this book to be ideologically neutral. It doesn't take a position on any of the issues. That we want it to be a book that whether somebody is more pro-prosecution or more defense or more conservative, more liberal, they'll be equally comfortable using the materials in the book.
And in addition to the big cases, we also give in that background material if there are applicable ethical rules that need to be considered, whether by a prosecutor or defense counsel, or how discretion goes into these decisions and what factors might be in there. So when people look at issues, they're not taking them out of context of how they really work in the criminal justice.
And I imagine this approach is consistent throughout editions of the book, since, Erwin, you said you're using the 4th edition now. So what is new to the 5th edition?
I think what's new is what the Supreme Court has done since the 4th edition. The Supreme Court is always deciding criminal procedure cases. And so there was a major case with regard to Miranda and whether or not there can be civil suits to enforce Miranda, Vega versus Tico. I think it really changes how students, lawyers, judges need to think about Miranda is constitutionally required. So we include that. Another example is, and I think this is distinctive about the book, we decided that we're going to include material on excessive police force. Many criminal procedure books don't include that. And I think we made a mistake prior to the tragic death of George Floyd that I don't think our book included enough on this because it's all 4th Amendment. The Supreme Court in Graham versus Connors said 1989 that any claim under the Constitution for excessive force has to be brought under the 4th Amendment. We include this material. And there's new cases, including last year from the Supreme Court, Barnes versus Felix, about that we include in the new edition. We also include more material on remedies than books usually do in criminal procedure. Criminal procedure books always include the exclusionary rule, but there is another remedy that's there, and that's the ability to bring civil suits. In fact, many of the cases in the investigation part of the book arise not from suppression motions, but from a civil suit. Well, students, when they go off to practice, need to know when can there be a civil suit? Against whom? What are the defenses? And so the new edition has some additional material on that. And I'll let Laurie talk about the many cases with regard to adjudication that are different for this edition because they've just come down from the Supreme Court.
Right. The Supreme Court's been very busy since our last edition, coming out with cases that range from everything on double jeopardy to the Bruton issue, which the court revisited, to confrontation clause, and then some cases that involve death penalty. But the real issue coming out of them is prosecutors' use of false testimony and due process violations. So we updated the cases, not just by slapping them in and adding them on, but really seeing where they apply and making sure everything before it is properly introduced and edited so students know the trajectory of these cases.
And what has that trajectory been?
Well, interestingly enough, I think it might be slightly different for the 4th Amendment than it is in some of the adjudicative areas. I'll let Erwin talk about the 4th, 5th, and 6th Amendment. That's the first half of the book. What I'm doing is finding some crumbs that are coming up in some of the latest decisions by the Supreme Court, where they've said that evidentiary violations could actually be due process violations. We hadn't heard that before, and students weren't even thinking that way. On the other hand, the court is still the court. So when it comes to double jeopardy, and dual sovereignty, they're expanding that doctrine. What's helpful for the students, I think, is that they can learn the basic doctrine so that they can appreciate what these new cases do and don't do.
I think Laurie puts that well. There have been more new cases in the last several years with regard to adjudication than there have been with regard to investigation. It used to be that the Supreme Court was deciding 3 to 5 4th Amendment cases a year. That drops off. after 2021, though this term the Supreme Court has a Fourth Amendment case that was just argued on October 15th, case versus Montana. One other part of the book that I would mention that we haven't talked about, and then go back to your question, and that's the last chapter of the book focused on habeas corpus. And one of the interesting choices that was made for the prior edition that we continue is that the habeas corpus chapter is not part of the printed book because most courses don't cover habeas corpus, but some do. So it's a full chapter of the book, just as it would be printed, but it's available online. If I were to talk about investigation and habeas corpus together, I would say the trend over the last several decades has been both to constrict the scope of rights and also to limit the remedies that are available. Not always. There are certainly cases where criminal defendants have prevailed under the Fourth Amendment or Fifth Amendment. There are instances where habeas petitioners succeed. But overall, I would say that the Supreme Court has limited the scope of Fourth Amendment, Fifth Amendment, habeas corpus rights, and the Supreme Court has also made it harder to get remedies, whether it's the exclusionary rule or money damages or habeas corpus.
I think that's exactly right. And for students to actually appreciate what's happening here, the professor should have the flexibility to decide how much they cover. Time is always of the essence in any class that you teach. I've been teaching close to 40 years and Erwin too. So we have seen the pressures on professors. We wanted where the professor certainly could get through the basic material, then focus on things that really meant something directly to them. Maybe it relates to work they're doing. For example, I created an innocence project. I'm more likely to cover some of the habeas than maybe some other professor.
So let's talk about how a professor might approach this. Is the book intended to be generally for a 3-credit criminal procedure upper level course? And how might a professor pull it apart or have a different focus if it were a shorter course or a course with a more distinct focus?
There is no consistent way that criminal procedure is taught across the United States. In some schools, there's one course on criminal procedure that covers both investigation and adjudication. Many schools, including mine, offer separate courses on criminal procedure investigation as opposed to criminal procedure adjudication. I'm teaching criminal procedure investigation, as I said, this semester, and it's a 4-unit, 1-semester course, and it focuses only on investigation. And I find in a 4-unit course, I can cover the investigation part of the book. Obviously, if I had 3 units, I would cover less, could talk about some of what I might delete. And if I had a single semester for both investigation and adjudication, then it's going to be much more of a survey. And there's going to be places where it's going to have to be about breadth, not depth of coverage.
And I would add this. We also have sort of the upper division investigative criminal procedure, but we've also offered as an elective to our first years. Now they get an elective and they get a criminal procedure, but it's really the bail to jail, the adjudicative, and they can relate to that. And the materials we have can be gone through, even for a first-year student in a 3-unit elective, give them a basic sense of what's going on.
Why do you think that this is one subject that is taught so inconsistently across the country?
I teach constitutional law, and it's also taught inconsistently across the country. Some schools do a year-long constitutional law class. Some do a course on structure of government and then another on individual liberties. The school where I teach, it's a 1-semester course that covers separation of powers, federalism, individual liberties, equal protection, but it doesn't cover the First Amendment. I'm used to the idea that it's not standard in how something is going to be taught. And the goal in writing the book is so that it can be used in any of these courses. And we wrote the book in a way that the material could be taught in any order, that we're very careful not to assume that people who are reading chapter 6 have necessarily read chapter 2.
And I think also importantly, we have that introductory chapter that gives people an overview and the really core values that they're going to be talking about, with right to counsel and the like throughout the class. So any class can start with that and then pick the chapters that work for that professor.
Marvelous flexibility for professors in looking at this book and considering how to use it. As you look at this 5th edition and what you've included and the trajectory that you've shared that you've seen with the court, what issues do you see might be ripe for a 6th edition down the line? Where do you think the court is going to be focusing as continued terms come along?
There are so many issues with regard to the Fourth Amendment and technology that the Supreme Court hasn't dealt with yet. And I spent a lot of time in the class covering things like if police put a poll camera outside somebody's home and monitoring the going in and going out, is that a search? If police get all the phone numbers that are connected to a cell tower at a given moment in time, is that a search? And then we can go on with all sorts of technological issues. And what's stunning to me as I presented to the students on so many of these questions, there's a split among the circuits and the states, and the Supreme Court hasn't taken them up yet.
And I think on the adjudicative side, we are seeing in the last few months the Department of Justice do things that we would say they haven't done before. And those cases are just making their way to the Supreme Court, and it will take time. So I would anticipate that in the next edition, we will have those cases or whichever come out to add or discuss it.
Oh, yes. I think you will have plenty to include in future editions. I thought you might mention the technology, Erwin, and I was just reading where in order to find lost pets, one of the big video doorbell companies is agreeing to provide all the footage from a neighborhood to try to find those pets. And allegedly, you're automatically opted in. And it's just things like that people don't even consider might be happening and might include, what they were doing on their own property.
And then when the police obtain them, is that a search? Is there a reasonable expectation of privacy? But this comes up all the time. I was just reading of an instance. New Jersey was taking blood from every baby when born to do genetic testing. And that blood was then used to catch the baby's father for a crime. Well, how does that relate to the Fourth Amendment?
My goodness.
Kinds of things.
Yeah. Wow. Well, it must be a fun course to teach because there are so many different issues like this that relate to our everyday life, right? There are things that your students can certainly imagine or that could happen in their own everyday existence, especially with technology. If a faculty member is considering whether or not to adopt the book, is there anything we haven't covered that you would share and say, this is why you really think Criminal Edition, 5th edition is the book that they should adopt?
I'm going to jump in and say anything that Erwin Chemerinsky has touched, you should take. I've lived by that, and it's really been joy of my teaching experience. I do like that the book is the way it is. It's well edited. It has previews. We don't try to confuse the students. But I also like that there is the teaching companion. So there are PowerPoint, there are slides, there are videos of some of the most high-profile things you might use. If you talk about the Terry case, we've got audio from the Terry argument. You talk about Hippo, we have the video from that. We have the bells and whistles. Some professors like it, some don't, and it may very much depend on your class. But I think people should consider this book because the book itself is all you need, and you're given the option of having more.
I, of course, would say the same thing about using the book because Laurie Levenson is the co-author of it. And I've got to give Laurie full credit for things like the PowerPoints and the videos. I've never learned how to use PowerPoint. I don't know how to use videos in class. Laurie has put all this material together. But let me answer your question directly with something that neither Laurie nor I have said. There's also a teacher's manual for the book, and we work hard to update the teacher's manual for the new edition. And it's really our class notes. It's how we teach this material, and we've put it together, and I hope that's useful for instructors. Obviously, every instructor has a separate approach to teaching any class, but maybe seeing how Laurie and I do it will be helpful.
I absolutely agree. And in those notes, we have sort of the summaries, but we also have the questions because we realize in this area, there are all these open questions.
And when you're considering those open questions, I'd love to hear from each of you one that you are spending the most time considering right now in your teaching and in your writing as experts in the field.
Maybe it's because it's the part of the class that I'm going to get to this week, but maybe it's also when I'm most involved in litigating these issues. And that's the questions of excess of force and remedies. Rights are meaningless unless there's remedies. And I think that the Supreme Court has really made remedies much more difficult with regard to criminal procedure. The court has cut back on when the exclusionary rule applies, but I'm especially focusing when it comes to excess of force and how difficult the court has made it for plaintiffs to recover, doctrines like qualified immunity. And as I'm going to be teaching this material on Wednesday, one of the things I really want to focus on for my students is imagine that ICE agents use excessive force. How can they be held accountable? What can they be sued based on? How likely is to be sued? What remedy can be provided against them? And I think at this moment in time, it's something really important to think about, but also focus on the larger question of, are there adequate remedies when there's violation of rights?
And I'd say in the adjudicative area, it's a real opportunity for students and professors to think about doctrines that we almost didn't pay enough attention to because of their history, like the grand jury. But all of a sudden, the grand jury is back in the news, and really thinking about the role of it is important. How about right to counsel? When now counsel is not being paid, what does that mean for the Sixth Amendment right? So I think taking these basic principles, even a unanimous jury, that law has changed recently. How does it fundamentally change what we want our criminal justice system to do? And what is that in terms of finding justice?
Such important questions. Yes, public defenders not being paid, also not being able to find enough public defenders, right? In certain areas, especially rural areas. Well, congratulations on the book, the 5th edition of Criminal Procedure, that will be coming up or coming out shortly this fall semester. And before we conclude, I'd love to know from your teaching of all of these issues, what the students are finding most difficult to grapple with the state of the laws today and current events.
I think one of the things that's different about criminal procedure in the classes that I teach is the students constantly have endless hypotheticals. Whenever I teach something, it's, well, what about this? And what about that? And of course, all of those are the matters that are going to come up. But I would say right now at this moment in time, there's a lot of focus on ICE and what the agents are doing. How does the Fourth Amendment apply? What remedies are available?
I agree. And, students are coming back to ask basic question, is it fair? Not the question of whether is it on the exam, which I'm sure they're concerned about, but really the deep moving questions about is it fair and how does it affect people they know or people that they hear about in the news?
Well, we're finding the same thing here. Our students are really hungry for discussions of what the law is and how it should apply and how it is applying. That curiosity is so important. And so I'm glad that you're addressing these issues with your students, and my professors are as well. Before we conclude, I would love to find out from each of you what your predictions are for the future of legal education in the coming decade.
In one sense, legal education is likely to be a lot like it is now 10 years from now, just like it's a lot like it was when I started law school 50 years ago. The students are still taking the same basic courses. They're using the case books. I hope 10 years from now, students will be using the 7th or 8th edition of our casebook in criminal procedure. I think it's because law schools are generally successful in preparing students for the practice of law, including at the highest levels of the profession. But if you ask me what I'm most worried about with regard to legal education, and that's accessibility and affordability. It hasn't gotten much attention that Congress in the large budget bill eliminated a crucial loan program, Grad Plus Student Loan. It's put a cap on student loans at $50,000 a year for law school. Most law schools, or at least mine, are substantially more expensive than that, even for in-state students, and that doesn't count expenses. And I've always felt that legal education depends on the availability of loans. Otherwise, we just become something for the very rich to send their children to. And that's not what any of us want. And so if you ask me, my great concern going forward, it's going to be how do we maintain that legal education is affordable and accessible, especially in light of this new bill that was just passed.
You're so right. The elimination of the Grad Plus loan is huge. And I know all of us are struggling with that, figuring out how the future law students will be able to afford it.
And I, of course, agree with Erwin on that point, but I'd also like to know that one of the things that might be affected if there is not the funding is the opportunity for students to get their education both in a class where they'll learn materials like from our book, but also which I think build on what they learn in the classrooms. So what will it look like? I'm not sure. What I hope it looks like is an enthusiastic, really curious, eager group of young individuals who say, I want to know the the law, and I want to use it to help other people.
Well, that's an excellent point to end on, and I thank you both so much, Professor Laurie Levenson and Dean Erwin Chemerinsky. Again, congratulations on Criminal Procedure 5th edition, and keep doing the great work that you're doing.
Thank you so much for having us to do this.
Thank you. It was a real pleasure.
Well, if you've enjoyed this conversation and you would like to listen to additional thought leaders in legal education, you can find Aspen Leading Edge on your favorite podcast channels or on YouTube. Thank you.